Good day, Crime Talk aficionados. We have a big show for you today. Why, you may ask? Well, first, the judge issues rulings in the Bryan Kohberger case. Luigi Mangione is officially indicted in federal court in New York. Another last-minute motion in the Karen Reed case. P. Diddy's request to continue his trial has been denied. This day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Now, before we get started, I'm going to remind you, go to crimetalksearch.com, sign up for that background subscription service today. When you do, you can run as many background searches as you desire. And yes, you will even get updates if you choose that particular option. So when you sign up, you can run a background report on anybody here in the United States. The report is literally generated while you wait. It is then emailed to you, and you're going to get all types of information. For example, what are the cell numbers associated with an individual? Email addresses associated with the individual that you are searching. Their social media presence. Do they have a criminal history? Do they have liens? Do they have judgments against them? Everything you want to know. Criminal history, right? Are they on one of those sex offender registries? Things you want to know and find out. So go to crimetalksearch.com, sign up for that background subscription service today. You're going to be happy that you did. All right, let's go ahead and open the record for Friday, April 18th, 2025. And ladies and gentlemen, we have a huge, big show for you today. Why? Because hot off the presses, at as late as 10:32 today, the judge in the Bryan Kohberger matter has issued some very important orders based upon the motions hearing that was held a couple of weeks ago. And we have them all here for you. And yes, we have important ones. For example, defendant's motion in limine regarding the witness eyebrows, bushy eyebrow identification, the touch DNA order, the order regarding the motions in limine that were argued in court, the motion in limine order regarding the make and model of the suspect vehicle, and the order regarding the neurological and psychiatric evidence that the defendant was going to try to backdoor in. So let's get to it. Now, I've told you in the past, I could summarize these and I will, but I think I'll give you the gist of it, the ruling, and then I'll go through the court's analysis because I think it's important. Now, I will leave out all the legal citations because, frankly, that's boring. And if you guys really want to that hard, you could find it yourself. But I think it's important to go through as to why the judge made the ruling. Now, and I don't want to sound like I'm bragging, but I am going to say I think I got all of these correct, the way the judge was going to rule. Most of these are trial issues. These were Hail Mary attempts by the defense, and I'm not bashing the defense. So all the people say, oh my God, Scott, you're so biased toward the defense. No, I'm looking at it from a legal perspective and trying to give you the analysis that is more than likely what's going to come out. If you're going to go to a bunch of wackadoo channels that are going to tell you what you want to hear and come up with the most crazy and obnoxious things, you can go there. All right. But the reality of it is, if you want straightforward legal analysis, this is where you come. All right. I have no reason to lie one way or the other. You know, it'd be great to do this full-time job, but I'm not going to put my credibility on the line for a few clicks for a video. It's not the way it works. Okay. I would give you legal advice. Not that I am, but I would give you my analysis just like I would give it if you were a client of mine. Okay. I got to tell you the good, the bad, and the ugly for the case. You can't ignore the bad facts, and a lot of people like to do that. All right, so let's get to it. First, the order on defendant's motion in limine regarding the witness identification by bushy eyebrows. Introduction. DM, a roommate of the victim in this case, was the sole eyewitness to the intruder believed to have carried out the homicides at 1122 King Road. During her interviews with law enforcement and at the preliminary hearing in this matter, DM to describe the intruder as having bushy eyebrows. Defendant moves in limine to exclude any evidence at trial referencing bushy eyebrows, arguing DM's descriptions is unreliable and therefore irrelevant and or barred by Idaho Rules of Evidence 403, which means that it's prejudicial, cumulative, or confuse the jury. The state responds that DM's description is based upon her personal knowledge, is relevant, and there is no basis for exclusion. Oral argument was held on this matter on April 9th. After the court took the matter under advisement, the court concludes the DM's description of the suspect's eyebrows is admissible. The question of whether evidence is relevant is one of law, while the decision to admit relevant evidence is discretionary. On discretionary matters, the trial court must, 1, correctly perceive the issue as one of discretion, 2, act with the outer boundaries of its discretion, and act consistently with the legal standard applicable to the specific choices available to it, and 4, reach its decision by the exercise of reason. Facts. These are the findings of facts and conclusions of law that the judge is making. On November 13th, 2022, sometime before 4:19 a.m., DM observed a person inside her residence, which she shared with 4 roommates at 1122 King Road. DM placed several phone calls and sent several text messages to her roommates. The only roommates who responded was BF, who resided in a downstairs bedroom. They had 2 short phone conversations and exchanged texts. Within those phone calls and text messages, DM relayed to BF she saw a person in the residence wearing black, and he had on a ski mask that covered his forehead and mouth. The same day at approximately 11:56 a.m., a 911 call was placed from 1122 King Road for a reported unresponsive female. Moscow Police Department responded to the scene, and Officer Mitch Nunez took a statement from DM. She told Officer Nunez that she saw a male, not insanely tall, wearing all black and a mask that was just covering his forehead and mouth. Later, DM repeated the description. He was a little bit taller than me. I couldn't really see much of him, and I'm almost positive he was wearing a full black outfit, and he had this mask that was just over his forehead and over his mouth. DM gave the description a 3rd time, repeating he had a mask. He was an inch or 2 taller than her. He was, basketball player kind of skinny, and the voice she did not recognize. DM also told Detective Nunez she was kind of in and out of it because I was so scared, and I was really tired. She did not mention anything during the interview about the intruder's eyebrows. At approximately 1:47 p.m. that same day, DM was interviewed at the Moscow Police Department by Detective Lawrence Mowry. During this interview, DM reported she saw a white male she did not know, maybe my height, a few inches taller, skinny, athletic build, wearing all black, wearing this mask that covers just his forehead and here. Regarding his height, she reported, I'm 5'10", so he's probably around 6 foot. She responded no when asked if she saw the color of his eyebrows and added, I don't remember what his eyes look like either, but she says she saw his eyes and he was definitely a white guy. She again mentioned she was in and out of it because she was tired and explained everything was kind of blurry. I don't fully remember it, I would say. 4 days later, DM was interviewed by the Idaho State Police, Detective Victoria Gooch, and the Moscow Police Department Captain Dustin Blaker. DM gave a detailed recounting of what she did on Saturday, November 12th, until she went to bed at approximately 3:20 a.m. on Sunday, November 13th. She stated that sometime between 4 a.m. and 4:20 a.m., she woke up and heard a male's voice that she did not recognize say, "It's okay. I'm going to help you." She said at this time she was out of it and probably still tipsy, and I believe I was also very drunk. DM opened her door and saw someone explaining, and I don't know how I knew it was someone because from my mind, it's like I was almost wearing these like blurry glasses, like it's fuzzy and cloudy, but it was like a figure of someone wearing all black. And it was like they had a ski mask that was covering their forehead and their chin and their mouth. And all I remember was seeing their eyebrows. And I don't remember that their eyes look like, but I remember their eyebrows. I don't remember the color of their eyebrows were. I just remember like bushy eyebrows. That's all I could think about. DM described the male as skinny tone, that basketball kind of type. DM states that she was 5'10" tall, so she thought the male was around 5'10" and then 6 foot, somewhere around there. DM stated that the male was approximately 3 feet from where she was standing, but added that could be off because I obviously probably still a little bit drunk. I just woke up. I don't remember fully. She reiterated, I know he looked at me because I could see his eyebrows. I think I just saw one eyebrow. I don't know why or how. DM then recounted calling and texting her roommate, BF, that there is someone in the house wearing all black and a ski mask. Conveyed to the interviewer that she did not know for sure if it's fully happened. I don't know if my mind's like making stuff up. It just doesn't make sense to me, and I don't know how to fully explain it, I guess. Detective Gooch explained to DM that the most important thing was to tell only things that she knew were true, and DM agreed. DM also agreed that she was traumatized and it could have affected her memory. Detective Gooch also asked DM if she suffered from anxiety. DM responded that she did and added that she had a lot of lucid dreams of being like kidnapped or chased. She also indicated she would watch Criminal Minds and fall asleep to crime podcasts. Detective Gooch and Captain Blaker then sought to confirm the fact from DM's memory. DM reiterated that she saw a male figure in the hallway approximately 3 feet from her, was holding something. He was wearing all black clothes. His forehead was covered. He was wearing a mask. She remembered his eyebrows. Captain Blaker asked what was covering his face, and DM stated, I don't know. Weird looking ski mask. It was like the regular ski mask with like eyes, and because I saw his eyebrows and I thought I saw his nose and like part of his face, but I don't know. She stated she could not see the male's mouth and did not remember if she saw the nose, but confirmed, I know I saw eyebrows. And I don't remember his eyes. I just feel like I can see eyebrows. But I mean, that could be it. I mean, that would make sense why the forehead was covered and part of his head was covered. The investigators inquired if DM could provide a composite for an artist, but she said she could not. Again, she reiterated she did not remember what his eyes looked like. I don't remember what his nose looked like. I just remember eyebrows. I don't know exactly what the eyebrows look like at all, really. I just remember thinking like eyebrows. Yeah, bushy, but that's all. Like, I don't remember the shape. I don't remember like the color. I just remember like bushy eyebrows. That's the only thing I can remember. On November 13th and November 19th of 2022, law enforcement took photos of DM's bedroom. On the wall were many magazine photos and drawn pictures pinned to corkboards. The drawings were of human faces with an emphasis on eyes and eyebrows. Some of the eyebrows are heavy. On December 1st, 2022, 18 days after her first interview, DM was interviewed by forensic interviewer Aaron Williamson, and DM gave a detailed accounting of her day on Saturday, November 12th, until she went to bed on Sunday, November 13th of 2022. DM reported she heard a man's voice, and it wasn't Ethan's. It's like, it's okay. I'm going to help you. DM stated she saw an all black figure about my height, maybe a few inches taller, skinny build, wearing a mask. DM again stated, I saw like, I don't remember if it was just like one eyebrow or two, but it was just like this bushy eyebrow. She described texting BF about a guy in black and described the ski mask, stating, I couldn't see any of his hair, but I remember just like seeing it was like almost rectangular, like not the circle ones. It was rectangular because I remember seeing like, just like, I don't know how to explain it. Just seeing like this. Maybe I'd be to see like a cross, but I don't remember seeing his eyes, but I feel like his eyes were there. I could just see like an eyebrow. I feel like that's how I know he saw me, because I could see his eyebrow. Like if I can see his eyebrow, he can see me, she reiterated. From what I remember, I think he was just like walking past that little wall and going towards the kitchen. And I don't know, like I just remember seeing an eyebrow. I don't know why, I just see one. It was just like one bushy eyebrow. I don't remember the color, like the full shape. I just remember it being bushy. DM also drew the mask for the interviewer. While drawing, she gave a consistent description of the mask and noted the eyebrows. I don't remember if I saw one or two. Like it was just weird. DM explained that she had scary lucid dreams, but she would always know she was dreaming. When she saw the intruder, however, she did not fully understand whether it was a dream or not. She also indicated that when she first saw the intruder, she thought she might have a firearm. On December 29th, 2022, defendant was arrested in Albrightsville, Pennsylvania. The following day, on December 30th, 2022, 47 days after her first interview, DM was interviewed by the Idaho State Police detectives. They asked DM whether she had seen a picture of the defendant. She stated she had seen the mugshot, but had no clue whether the defendant was the person in the house. She explained, "From what I remember, I just remember seeing this figure that was like, not fat, obviously, but more like the skinnier tone build, and some mask on. I don't know what the mask exactly was, but when I thought about it, it was just like covering here and here. I don't know if it was covering his mouth, his nose, or below his mouth or nose. I just remember knowing that he was white, but I don't know how he was white. I just knew he was. And this knowing, there's like, I knew he had looked at me because of the bushy eyebrow. That's all I remember. But I had no idea what he looked like. I don't, like, when I looked at his picture, nothing came back to me at all. So that, like, I don't know. I feel like if I saw that, my mind would like, oh yeah, like that's, but just, I don't remember at all. When asked whether she told BF the male had a big nose, DM stated, all I remember, but I don't remember big nose at all. That's like, all I remember is like some bushy eyebrow in an all black and some sort of mask, but it wasn't like one of those circle ski masks. That's all I remember. On May 15th, 2023, 183 days after DM's first interview, DM testified at the grand jury proceedings for the above titled matter. Regarding November 13th, 2022, DM testified she woke up around 4 a.m. to noise. She testified she opened her door and heard a man's voice. "It's okay, I'm going to help you." And I didn't know who the man's voice was. DM testified she opened her door again and saw a figure in all black, which I believe was a person. I knew the person was white. I don't know how, but I just knew it. Knew it was male. I think I knew that was because of the voice. The person was around my height or a few inches taller, and then I knew his build wasn't like scrawny and he wasn't fat, so I figured it was like a basketball tone, lean build. Regarding what the person was wearing, DM testified there was like, from what I think I remember, it was like an all black, like a black mask, almost like a ski mask, but not. It just like covered the head and then maybe up to the mouth, maybe more. I can't remember if it covered just the chin, the mouth, or the nose or lower. She said the clothing was all black. DM also testified, well, the thing I can really remember was something about a bushy eyebrow. I don't remember seeing anything else, just remember about the eyebrow. Court's analysis. DM's testimony satisfies 601 and 602. Defendants first suggest that DM is not competent or lacks personal knowledge to testify about bushy eyebrows because her testimony is not reliable under the Mason's-Biggers balancing test, a balance that is applied when determining whether a witness's identification is reliable or whether it was a product of police suggestiveness. Defendant points out that DM's opportunity to see the intruder in her home was seconds at most. Her attention was influenced by sleepiness and alcohol, and she constantly questioned what she saw. Defendant argues DM's description of the physical characteristics of the intruder were general in nature and could fit millions of individuals. Defendant also notes that while he does not have bushy eyebrows, the artwork on her wall displays individuals with prominent eyebrows. As the state notes, however, Mason-Biggers test does not apply here because DM did not make an identification of defendant and her descriptions were not the results of the use of law enforcement identification techniques. In fact, the sole instance when DM was asked to identify defendant, when she was shown a mugshot after his arrest, she responded she had no clue whether it was the person she saw. Not to be deterred, defendant alternatively argues that the court should find DM unreliable based on scientific studies that explain the fragility and inaccuracy of memory. The court finds no basis to do so. As a general matter, every person is competent to testify as a witness under Idaho Rules of Evidence 601. Incompetency, which is determined by the court, applies to persons whom the court finds are incapable of receiving just impressions of the facts about which they are examined or of relating them accurately. 601A, additionally, a witness may testify to a matter only if evidence is introduced sufficient to support a finding that the witness has personal knowledge of the matter. D DM was a direct witness in this case, as the factual recitation set forth in detail. DM's account of what she saw and the physical characteristics of the intruder were remarkably consistent throughout all 5 interviews and her grand jury testimony. While she did not mention his eyebrows in her initial interview, she thereafter identified the bushy eyebrows on multiple occasions as something that firmly stuck out in her mind. Although she might have been intoxicated or tired or questioned her memory, the consistency of her description suggests a high degree of reliability. While the defendant may cross-examine DM about his concerns with her memory, his challenge to her competency and personal knowledge as a basis for exclusion are unfounded. Defendant next asserts DM's testimony about bushy eyebrows must be excluded under Rules 403, which permits exclusion of relevant evidence if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Specifically, defendant points out DM could not provide enough details about the intruder to provide a description to a composite artist. He asserts that to allow her to testify about bushy eyebrows would confuse the issues and result in unfair prejudice because the danger the jury will believe he is guilty due to his eyebrows. However, DM's testimony about bushy eyebrows is highly relevant in this case. DM is the only eyewitness to the intruder responsible for the homicides. It is the jury's task to determine whether defendant is that person. Further, there is nothing confusing about her testimony. Her description of the bushy eyebrows has been consistent and clear. While she could not provide enough details for a composite sketch, it is unsurprising given her observations that the intruder was wearing a mask on his face. Moreover, while his description might or might not implicate defendant, it will not result in unfair prejudice. Unfair prejudice arises only when the evidence has an undue tendency to suggest a decision on an improper basis and appeals to the juror's sympathy, arouses their sense of horror, provokes their instinct to punish, or otherwise causes a jury to base its decision on something other than established propositions in the case. DM's description of the intruder having bushy eyebrows will not reasonably compel a jury to find defendant guilty simply because he may have similar eyebrows. There is a large gulf between a finding that a witness is not competent to testify about what they personally witnessed and simply allowing impeachment by vigorous cross-examination. This is a matter for cross-examination by defendant, and any concerns with DM's ability to perceive and remember what she claims she saw is tested in that manner. Therefore, based upon the foregoing, defendant's motion in limine regarding witness identification of bushy eyebrows is denied. And so, once again, I said when we went through the analysis after the motions hearing that is questions for cross-examination. It goes directly to DM's ability to perceive, to recall, to recollect what she took place, how she was able to perceive that. She was tired. She was possibly intoxicated, according to her own words. That's something for the cross-examination for the jury to take into account as to what weight and credibility they give to that testimony. Remember, the jurors can always believe some, part, or none of a witness's testimony. So judge made the right call in that one, and not because he's anti-Bryan Kohberger, nor am I. It's just simply the way the law works. Next, order regarding the touch DNA and contact DNA. This is the one that gets everybody all spun up. So this is, once again, I think it's important to go through the court's analysis here. I'll kind of cut out if there's repetition as it relates to the previous motion as to the facts, but this has to do more with legal standards, all right? And once again, this is expert testimony. And but I think it's relevant for the whole court record to be put out there because it provides more information than, frankly, what we've been provided thus far, just like a few items in the order regarding the bushy eyebrows. So here we go. Order of defendant's motion in limine regarding Raylene Nolan touch and contact DNA. Defendant moves in limine to exclude the testimony of Raylene Nolan, the lab manager with the Idaho State Forensic Services Laboratory, who was disclosed by the state to testify about touch DNA and the transfer of DNA generally, and more specifically that the DNA located on the knife sheath was more likely the result of a direct transfer. Defendant argues that Ms. Nolan's testimony, as well as any other testimony referencing the terms touch or contact DNA, DNA and or purporting to be an opinion about the means or mechanism of how the DNA ended up on the knife is completely irrelevant or impermissible under Rule 403, and it fails to satisfy 703, which is the expert testimony rules. Oral arguments was held on April 9th. After the court took the matter under advisement, the court does not find the exclusion of Ms. Nolan's opinions is warranted. However, the court requests that the parties instruct their witnesses to avoid the use of the terms touch DNA, contact DNA, and trace DNA. The admissibility of the expert testimony is discretionary. Likewise, whether to exclude evidence under 403 is discretionary. On these discretionary matters, the court must perceive that the issue is one of discretion. Second, act within the boundaries of such discretion. And third, act consistently with any legal standards applicable to the specific choice before it. And four, reach its decisions by an exercise of reason. Facts. A knife sheath was recovered from the crime scene in this matter and swabbed for DNA. A sample of DNA identified as Q1.1 was extracted from the swab by the Idaho State Forensic Lab. The DNA concentration was 0.168. It was subsequently tested using standard DNA STR, short tandem repeat methods. The STR profile developed revealed that the DNA came from a single source male profile. The state disclosed Rylene Nolan, the lab manager for the Idaho State Lab, to testify to the operations of a forensic laboratory, the structure of the lab, and the types of evidence it processes. Her disclosure further states Ms. Nolan will testify to touch DNA and transfer of DNA. Specifically, Nolan will testify to the characteristics and nature of touch DNA, including how it is deposited and transferred to an item of evidence, the methods used to collect and preserve touch DNA samples from items of evidence, the procedure and protocols used by forensic scientists to extract and analyze touch DNA, the manner in which results from the touch DNA samples are interpreted, and the reliability of touch DNA. DNA analysis and its acceptability in the field of forensic science. Nolan will also testify to the potential of DNA to transfer between an individual and an object, including the distinction between primary and secondary transfer and the factors influencing the likelihood of transfer. On February 17th, 2025, the state submitted its rebuttal disclosure, including one from Ms. Nolan. The focus on the second disclosure in touch contact DNA and direct versus indirect transfer included factors that can influence the transfer and persistence of DNA on an item. The final paragraph of her rebuttal disclosure states, many complicated factors can influence the likelihood of transfer of DNA and the persistence of the transferred DNA after deposit. Current DNA technology cannot conclusively answer the question of when DNA was deposited on an item or by what mechanism, either direct or indirect. It is possible the DNA detected on M2002-484 item 1.1 resulted from secondary transfer. However, based upon Nolan's training and experience, it is her opinion, given the quantity of the DNA detected on the item, the 0.168 nanograms, and given the DNA profile obtained in a single source, it is more likely the result of a direct transfer. Court's analysis. Defendant argues it's threefold. First, he seeks to exclude any testimony by Ms. Nolan regarding when and how DNA found on the knife sheath was transferred there, arguing it conflicts with the current consensus within the forensic scientific community, is outside her expertise, and it's speculative. Second, he argues generally that the use of the term touch and contact DNA should be prohibited at trial as misleading, confusing, and unfairly prejudicial. Finally, he argues that Ms. Nolan's rebuttal opinion must be stricken as improper rebuttal. Each will be addressed in turn. Ms. Nolan may offer disclosed testimony about DNA transfer. If scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact and issue, a witness qualified as an expert by knowledge, skills, experience, training, or education may testify thereto in the form of an opinion or otherwise. That's 702. To determine whether expert testimony is admissible, the district court must consider two factors. First, to give expert opinion, a witness must be qualified as an expert on the matter at hand. Second, once the witness is qualified as an expert, the trial court must determine whether the expert's opinion testimony will assist the trier of fact in understanding the evidence. An expert opinion, which is speculative, conclusory, or unsubstantiated by fact in the record, is of no assistance to the jury in rendering its verdict and therefore is inadmissible as evidence. Ms. Nolan is sufficiently qualified. Whether a witness is sufficiently qualified as an expert is matter largely within the discretion of the court. In arguing Ms. Nolan is not qualified to render an opinion on DNA transfer, the defendant contends that within the forensic community there is a consensus that only experts specially trained in DNA transfer are qualified to render such an opinion. He asserts that as a lab analyst, Ms. Nolan does not have the expertise to proffer an opinion in this case as to how DNA was transferred to the sheath. To establish this consensus, defendant relies on two forensic scientific publications regarding DNA transfer, both of which recommend that DNA analysts should avoid rendering opinions regarding DNA transfer absent specialized training. The first article, authored by 5 forensic scientists in 2019, discusses what we know about DNA transfer and the associated elements of DNA persistence, prevalence, and recovery, sometimes referred to as DNA TPPR. The express purpose of the article is to assist caseworkers' investigations of criminal activities, and the information therein should be used where relevant. It further states, appropriately trained forensic practitioners are best placed to provide opinion and guidance in the interpretation of profiles at the activity level. However, those requested to provide expert opinion on DNA-related activity, level 3 issues, are often insufficiently trained to do so. We advocate recognition of DNA activity associated expertise to be distinct and expertise associated with the identification of individuals. This is to be supported by dedicated training, competency testing, authorization, and regular fit for purpose proficiency testing. Notably, the journal, which the article appears, Forensic Science International Genetics, is an international one, and each of the 5 scientists are from outside the United States. The second article is reportedly published in May of 2024 by a group of individuals referred to as the Expert Working Group on Human Factors in Forensic DNA Testing. The express purpose of the report, which was sponsored by the U.S. Department of Commerce's National Institute of Justice, Office of Investigations and Forensic Science, was to conduct a scientific assessment of the effects of human factors on forensic DNA interpretation with the goal to recommend strategies for improving production, evaluation, communication of DNA results. Section 7 of the report is dedicated to DNA transfer, specifically the how and when questions with regard to expert testimony regarding the transfer of DNA. The report explains that except in ground truth known experiments where an individual is observed to have been in contact with a surface location, it is not possible to know whether the transfer was direct or indirect. It is further stated that the provided opinions about the probability or possibility of direct or indirect transfer is problematic, stating, evaluations considerations, factors such as transfer, persistence, and background require an evaluation of the biological results given propositions that address not the source of the DNA, but the activities that may have taken place. This in turn requires the use of data, knowledge, and expertise on DNA transfer, persistence, prevalence, and recovery, rather than acknowledge the DNA profile characteristic, probabilistic genealogy typing software, and population frequencies. In this regard, DNA TPPR and assessments given activity levels propositions are a separate skill distinct from standard DNA profile and interpretation. It may be a function limited to only a portion of DNA analysts with a required expertise. At present, there are no adequate educational opportunities to inform these types of issues within the United States. The report goes on to note that an expert rarely, if ever, has all the information needed to perform a robust, balanced, and transparent evaluation of biological results regarding transfer or specific activities on the witness stand. Consequently, the report advanced the following recommendation. DNA analysts should not opine about the possibility or the probability of direct or indirect transfer having occurred in a case. Based on these 2 articles, defendant persists that Ms. Nolan, as a typical lab analyst is not qualified to substitute her judgment in the face of the weight of forensic community agreement that the science and literature does not support any analyst testifying about when and how of transfer. The state responds the defendant argument is both legally and factually flawed. The legal flaw is that it misapprehends and the appropriate standard to determine admissibility of an expert opinion. The state asserts that the standard is not the consensus of the scientific community, but on whether her knowledge will assist the trier of fact. The factual flaw is defendant's failure to mention the lack of consensus in the EWG report testimony regarding recommendation 7.1. Footnote 455 of the article notes that 2 EWG members dissented from the recommendation, stating while the dissenters acknowledged that analysts are often asked to respond to how and when questions in criminal cases and agree that testimony on this subject can be misleading or otherwise problematic, they believe that the broad prohibition in recommendation 7.1 puts the proverbial cart before the horse by not first requiring an assessment of the type outlined in recommendation 7.3. Moreover, they worry that supporting 7.1 would imply the need for analysts to shift to a new paradigm that has not yet been sufficiently vetted within the specific context of the United States court system. The court finds Ms. Nolan to be sufficiently qualified to render her opinion on DNA transfer, despite her lack of specialization in DNA TPPR. The test for determining whether a witness is qualified as an expert is under 702 is not rigid. A qualified expert is one who possesses knowledge, skill, experience, training, or education. This language is intended to provide wide latitude in how a witness may qualify as an expert. In situations where a witness has a general expertise in a broad subject, but is not a specialist in the specific aspect of that subject that is pertinent in this case, most courts conclude that the general knowledge can be sufficient to qualify the witness as an expert. This is because the issue under 702 is simply whether the testimony of a witness with only a general background is reasonably likely to help the trier of fact, not whether a specialist would be preferred. Differences in expertise bear chiefly on the weight of the assigned to the testimony by the trier of fact, not its admissibility. According to her affidavit, Ms. Nolan is currently qualified and proficiency tested as a DNA analyst and has been so qualified for 20 years. Her CV reveals that she's worked as a forensic scientist, biology, DNA at the Idaho State Police Forensic Services Laboratory for 11 years before becoming its manager. She is certified by the American Board of Criminalists and is a molecular biology fellow. She is a member of 4 professional organizations in the forensic field. She has taught courses to law enforcement and medical personnel on DNA in the forensic context and has published scholarly articles on the subject. Based on her professional experience in the forensic DNA field, Ms. Nolan, at the very least, possesses the general expertise to opine to matters of DNA transfer. Given her general expertise and lack of specialized DNA TPPR training as advocated by defendant's authorities, goes to the weight of her testimony, not its admissibility. Further, in challenging her qualifications, defendant is seeking to hold Ms. Nolan to an aspirational standard of expertise in the forensic field that is, for now, is nothing more than a recommendation, and a disputed one at that, with a segment of the forensic scientific community. Not only do defendant's articles fail to establish any established standard of qualification, Ms. Nolan disputes that there is a consensus in the forensic DNA community that DNA lab analysts should not opine as to whether DNA TPPR. She points out that not only were there dissenters to the EWG's recommendation 7.1, there's a divide in for forensic DNA community on this topic. She explains, one side of the EWG's recommendation, the other side believes that not offering an opinion based on knowledge of molecular biology, DNA, when it may aid the trier of fact, is unethical. At the most recent American Academy of Forensic Scientists meeting held in Baltimore in February 2025, there was a presentation supporting both sides of this argument, demonstrating the current divide in the community. More importantly, Idaho has not adopted the standard for admissibility set forth in Daubert, which considers, among other things, whether the expert theory is commonly agreed upon or generally accepted. Therefore, whether there is a general consensus supporting Ms. Nolan's opinion is not irrelevant to its admissibility. Notably absent from either party's briefing and court case discussing the issue whether DNA analysts are qualified to testify at DNA transfer. A review of case law reveals that such opinions are offered by DNA experts without dispute over qualifications. It appears only one court, a military court, has squarely addressed the issue and has declined to find the DNA analyst was unqualified to render testimony. In doing so, the court rejected the notion that DNA transfers was a separate science from DNA extraction and analysis, and therefore the expert in DNA was qualified to testify. In sum, given the liberal standard for qualifying a witness, Ms. Nolan's experience and training in the area of the forensic analysis of DNA generally, the current divide in the forensic community regarding whether lab analysts are qualified to testify of DNA transfer, and the lack of jurisprudence on this matter, the court declines to find that Ms. Nolan lacks the qualifications necessary to opine on DNA transfer. Defendant's challenges to her qualifications affect simply the weight to be afforded her testimony. The judge goes on and says that Ms. Nolan's testimony will assist the trier of fact. Having determined Ms. Nolan's qualification as expert, the court must determine whether testimony will assist in the trier of fact in understanding the evidence. The condition goes primarily to relevance. One aspect of relevance is whether the proffered expert testimony is sufficiently tied to the facts of the case such that the testimony will aid the jury in resolving the factual dispute. An expert's opinion that is speculative or unsubstantiated by the facts in the record is inadmissible because it would not assist the trier of fact. If the expert testimony is competent and relevant, it may be admissible, and the weight given to the testimony is left to the trier of fact. The defendant argues Ms. Nolan's rebuttal opinion that the DNA detected on Q1.1 is more likely the result of a direct transfer is speculative because it offers possibilities that are not based on substantive scientific principles. The state responds that Ms. Nolan's rebuttal disclosure sufficiently explains the scientific principles underpinning her opinion and the reasons for her opinion. In addition, the fact that Ms. Nolan cannot testify conclusively as to when and how the DNA arrives on the knife sheath does not, according to the state, render her opinion speculative or otherwise unhelpful to the jury. The court finds Ms. Nolan has identified an adequate scientific basis for her opinion. Her rebuttal disclosure reveals that she will discuss the differences between single-source DNA profiles and mixtures, concepts pertaining to direct and secondary transfer of DNA, and the variables that can influence the transfer, persistence, and recovery of DNA. In fact, this discussion closely mirrors the TPPR DNA principles advocated in the article cited by the defendant. And while the defendant may not think Ms. Nolan is adequately qualified to offer an opinion of DNA TPPR, there does not render her opinion devoid of scientific principles. In addition, although Ms. Nolan admittedly cannot testify conclusively as to whether the DNA was transferred to the sheath by direct contact rather than indirect, this does not render her opinion speculative. Testimony is speculative when it theorizes about a matter as to which evidence is not sufficient for certain knowledge. An opinion is speculative suggests only possibilities that may be properly excluded, since the opinion would not assist the trier of fact. Ms. Nolan's opinion does more than suggest possibility. She states that while it is possible the DNA on the knife sheath was from secondary transfer, it is more likely the result of direct transfer, given that 1, the DNA was a single source profile, and 2, there is a 0.0168 nanogram of DNA detected on the sheath. As the state points out, an expert may testify to the likely opinion, particularly when the expert acknowledges the limitations of such opinion. In State v. Hall, for example, the forensic pathologist testified that based on the lividity patterns observed on the victim's body, he believed the victim was most likely hogtied after her death. In finding the opinion properly supported, the Idaho Supreme Court found this testimony was not based upon mere speculation or possibilities, but was based upon the lividity patterns. In addition, the court notes that the expert admitted the limitations of his opinion. Ms. Nolan's opinion is no different. She will testify that based on scientific principles regarding DNA transfer and her observations of the quantity of the DNA and type of profile found on the knife sheath, it was more likely a direct transfer rather than a secondary transfer. Further, the fact that she admittedly cannot render a conclusive opinion about how the DNA arrived on the knife sheath and that it is possible it was through secondary transfer does not render her opinions inadmissible. It is simply an acknowledged limit on her opinion. Neither party has cited to case law discussing the admissibility of expert opinions on DNA transfer. However, the cases reviewed by the court indicate that Ms. Nolan's opinion is acceptable despite her inability to reach a definitive conclusion. In United States v. Perez, the government's DNA expert testified about the DNA transfer with regard to a mixed DNA profile found on a gun, 85% of which was attributable to the defendant. He discussed the difference between the direct and secondary DNA transfer and the variables that can affect DNA transfer. He further testified that the amount of DNA found from a secondary transfer when compared to a direct transfer is expectantly less, specifically stating, "I haven't seen an example where the primary toucher has less DNA than the secondary person, and typically the initial touching is going to give more DNA." He did testify that it was possible, but in general, he would think the direct touching is going to transfer more of the individual's DNA. Based on this testimony and the fact that the 85% of the DNA was attributable to the defendant, the court concluded that a jury could reasonably infer that the defendant's DNA was deposited by direct transfer. In State v. Glass, the court found, based upon the lack of expert testimony regarding DNA transfer, that there was insufficient evidence to uphold his conviction. In that case, DNA was recovered from a latex glove at the scene of the crime. Analysis revealed a mixed profile, the result of which is consistent with the defendant being the major DNA profile. The expert stated she could not, however, determine from her testing whether the transfer was primary versus secondary. The court found the fact that the defendant was a major contributor was alone not sufficient to establish the defendant's identity as the perpetrator. The court noted, the DNA expert testifying in both the United States District Court for the District of Connecticut and courts in other jurisdictions, however, have offered the evidentiary basis lacking in the present case. That is, the correlation between the amount of DNA deposited on the item and the likelihood of such DNA was deposited via primary transfer as opposed to secondary transfer. Among those cases cited by the Glass Court was Perez. As concluded in Perez, the Glass Court found that testimony correlating the amount of DNA on an item with the likelihood that it was transferred via direct and indirect transfer can provide a jury with an evidentiary basis from which it reasonably can infer the defendant, having been designated as a major contributor to the mixture of DNA, makes it more likely the defendant's DNA was deposited via primary transfer. These cases demonstrate that it is not outside the permissible bounds of expert testimony to opine as to the likelihood of DNA transfer, and in fact, such opinions can be crucial to putting the DNA evidence into context. Indeed, Ms. Nolan is offering the very opinion that the Glass Court found lacking, i.e. the correlation between the amount of the DNA deposited and the likelihood it was transferred by direct or indirect contact. This will aid the jury in understanding the evidence. Consequently, her opinions will not be excluded. Misleading levels are to be avoided. Defendant next argues that the term touch or contact DNA should be excluded under Rules of Evidence 403 because it could mislead the jury into inferring that the depositor of DNA actually touched the object on which it was found. The state only addresses the term touch DNA and argues it should be allowed because it is a common term in the field. Further, the state points out that it will be clear to the jury from Ms. Nolan's testimony that touch DNA is a term used only to distinguish that type of DNA of other kinds of DNA. Relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The issue here is whether the word touch is prejudicial as it implies that the DNA was transferred via touch. Touch DNA is a shorthand reference for the epithelial or skin scales that may be left behind on an object when it is touched or comes in contact with the skin. It is a common term in DNA forensic field. Indeed, scientific and legal literature as well as case law is replete with reference to touch DNA, including 2 articles relied upon by the defendant. In fact, defendant's own expert, Dr. Ruth Ballard, references touch DNA in her report. However, as one of the defendant's article observes, the term touch DNA can be misleading as it implies a specific mode of action, to some degree also the type of biological source. Instead, the author suggests using the terms trace DNA, which is less descriptive. Ms. Nolan, however, disagrees that trace DNA is a better term, stating the term trace DNA implies amount. The word trace is defined as a very small amount and is used in the scientific literature when describing evidence samples with low amounts of DNA that do not yield a profile or only a partial profile. I would not be willing to use the term, and it would be inappropriate to apply the term DNA on the sheath because a trace amount is not what I detected on the item 1.1, and referring to it as trace DNA would be misleading to the trier of fact. Given the ubiquitous of the term touch DNA in not only the forensic DNA field, but in the legal and scientific field as well, the court is unwilling to prohibit the term. There is too great a risk that a witness or counsel will inadvertently refer to the term out of habit, potentially giving rise to a motion for mistrial for violation of the court's orders. Moreover, the court is not concerned that the jury will be misled, that both parties have DNA experts who can easily disabuse the jury of any mistake in correlating touch DNA with actual touching. That said, the court asks that counsel avoid the use of the terms as much as possible, so that any potential confusion can be bypassed. To this end, the parties are instructed to submit a mutually agreed instruction to provide to the jury in case the terms are inadvertently used. If a witness uses the term, opposing counsel can examine the witness about the broader meaning of the term within the forensic community, and the instruction may be given at that time. Ms. Nolan's rebuttal opinions are proper. Defendant's final argument is Ms. Nolan's anticipated rebuttal testimony is improper because it does not respond to any opinion by defendant's own experts regarding the DNA transfer. The court does not agree. Rebuttal evidence is evidence that explains, repels, counteracts, or disproves evidence which was introduced by or on behalf of the adverse party. As the state notes, defendant's DNA expert, Ruth Ballard, acknowledges there is good support that Mr. Kohberger's DNA was found on item 1.1, a swab from the knife sheath. However, her report indicates she will inform the jury that DNA on an item could be the result of indirect transfer from skin cells. The disclosure implies that the jury should give little weight to defendant's DNA on the crime scene because it could just mean defendant's DNA was nothing more than innocuously shed skin cell slash DNA prior to the crime, and the sheath could be picked up and transported to a crime scene by someone else who sheds no DNA onto it. She also opines that the DNA was found in a location that suggests it would persist for a long time because it was protected. Given Dr. Ballard's anticipated testimony, Ms. Nolan's rebuttal is proper. She will discuss the process of primary and secondary transfer, the variables affecting transfer and the persistence, and why she is of the opinion that the DNA knife sheath was more likely the result of direct transfer. Of course, if Ms. Ballard limits her testimony on the stand, the court can reconsider the scope of Ms. Nolan's rebuttal. However, based on Dr. Ballard's report, Ms. Nolan's anticipated rebuttal is appropriate. So, based on the foregoing, defense motion in limine regarding Rylene Nolan and reference to touch and contact DNA is granted in part and denied in part. Other than some clarification on some verbiage, some wordage, so to speak, basically the prosecution got what they wanted. Next big one, vehicle. Order on defendant's motion in limine regarding make and model of the suspect vehicle. A lot of people are saying you can't tell it's his car. Well, that's a question for the jury to decide. Here we go. In the early morning hours of November 13th, 2022, surveillance video from various locations near the crime scene picked up footage of what law enforcement believed to be the same vehicle as suspect vehicle 1. The white sedan that was seen arrive at and then depart from the area of 1122 King Road at the time of the homicides. From one such video, law enforcement determined the vehicle was a 2011 through 2016 Hyundai Elantra. Defendant seeks an order precluding the state from referring to the vehicle depicted on various surveillance videos as the same vehicle, suspect vehicle 1, and from asserting that suspect vehicle 1 is a 2014 to 2016 Hyundai Elantra. He argues that these are speculative conclusions that invade the province of the jury. The state responds that it intends to elicit expert testimony establishing the vehicles are the same, and such testimony will neither be speculative nor improper. Oral argument was held on April 9th, 2025, after which the court took the matter under advisement. The court finds that the state may present expert opinion that the vehicle depicted in the videos are the same vehicle as suspect vehicle 1, as well as the make and model thereof. Not going to go through the standard because we've already gone through that twice as it relates to experts. Facts. Following the homicide, law enforcement gathered video surveillance from various locations surrounding the crime scene, including 1112 King Road, a residence immediately to the northwest of the crime scene. That video footage showed a white sedan, suspect vehicle 1, enter the King Road neighborhood at 4:04 a.m. and then depart from the area at a high rate of speed at 4:20 a.m. The same footage showed that law enforcement believes to be the same vehicle make 3 initial passes by the crime scene in the 30 minutes before its 4:04 a.m. entry. Surveillance footage from 5 other locations within 0.6 miles of the crime scene also captured what law enforcement to believe to be suspect vehicle 1 in the hour preceding the crime. Based on the direction of travel and the timestamps from these videos, investigators mapped what they believe to be suspect vehicle 1's route of travel. One of the surveillance videos relied upon by law enforcement was from a camera located at 1125 Ridge Road. Video footage captured at 4:01 a.m. from this camera provided a clear view of the white sedan depicted therein, which law enforcement believe shared the same similar characteristics to a 2014 to 2016 Hyundai Elantra. While there is no continuous footage showing the vehicle identified in the Ridge Road footage traveling to the crime scene, the Ridge Road camera was located 0.3 miles down the road from the crime scene. From this collective evidence, investigators believe the vehicle seen on the Ridge Road footage at 4:01 a.m. was suspect vehicle 1 captured on the 1112 King Road footage at 4:04 a.m. Court's analysis. Based on the lack of continuous footage showing the vehicle captured in various surveillance videos traveling to the crime scene at 4:04 a.m., defendant argues it would be improper for the state to identify those vehicles as suspect vehicle 1 or otherwise identify suspect vehicle 1 as a 2014 to 26 Hyundai Elantra. He argues any such testimony is speculative and not relevant, unfairly prejudicial, and invades the province of the jury. The state responds that the testimony is based on logical, educated inference drawn by law enforcement from the surveillance videos. It adds that the testimony does not invade the province of the jury and is highly relevant to determine whether the vehicle captured at 4:04 a.m. on the 1112 King Road camera was defendant's vehicle. To the extent defendant is attempting to prohibit the state from arguing or asserting as fact that the vehicles are the same or that suspect vehicle 1 is a 2014 to 26 Hyundai Elantra, he is correct that it would be speculative and improper without expert testimony to provide a basis to make this contention. However, this prescription does not prevent the state from eliciting such opinions from law enforcement and asserting that this as an allegation during the trial based on the testimony. An opinion is speculative when it theorizes about a matter as to which evidence is not sufficient for certain knowledge and suggests only possibilities. Here, law enforcement's opinion that the vehicle captured on the Ridge Road camera at 4:01 is suspect vehicle 1, captured at 4:04 on the 1112 King Road footage, is not based on unsupported theories or possibilities. Rather, the opinion is based on the investigator's training and experience and educated inference drawn from their review of surveillance footage from 6 locations within a mile of the crime scene during the hours preceding the crime. From this evidence, the investigators were able to map what they believed was the suspect's vehicle route of travel preceding the crime, as well as identifying its make and model. Defendant ignores this collection of evidence and focuses instead on solely 2 points of reference. However, the investigators had multiple data points from which they could reasonably infer that the vehicle seen on Ridge Road at 4:01 a.m. was the same that had been seen driven throughout the area in the preceding hour, including the 3 passes by the crime scene. Further, based on the direction of travel of Ridge Road vehicle and its distance from and location respective to 1112 King Road, it is likewise reasonable to infer, notwithstanding the lack of continuous footage, that it continued traveling along Ridge Road until it reached King Road. Such opinion testimony would not usurp the jury's role as fact finder. The jury is tasked with determining whether the defendant committed the alleged crime. The state asserts that the perpetrator drove suspect vehicle 1, and based on the totality of the evidence, that it was the defendant's Hyundai Elantra. The investigator's observations and inferences about the route of travel of the vehicle, its make and model, whether the Ridge Road footage from 4:01 and the King Road footage from 4:04 a.m. depict the same vehicle, and whether the depictions were all the perpetrator's vehicle are relevant to this determination. The jury is free to weigh this evidence and the investigator's testimony against that offered by the defendant and decide for itself what that surveillance video depicts and whether it supports its ultimate conclusion bearing on defendant's guilt. Finally, defendant only articulated basis for excluding the testimony under 403 is that it would be prejudicial due to its speculative nature. Because the court has found otherwise, there is no basis for exclusion under 403, as its relevance is substantially outweighed by the factors which 403 is concerned. Based on the foregoing, the motion in limine regarding the make and model of the suspect vehicle is denied. That's just common sense, ladies and gentlemen. I get it. The defense is doing what they got to do. I would be making the same motions as well. But the reality of it is the jury is going to be the ultimate fact finder and say, is that his vehicle? And to say, well, you don't have a continuous video of it, therefore you can't opine that that's his vehicle. That's absolutely just ridiculous. But there you go. Next one, we're going to go through this very quickly, is the order regarding the motions in limine. All right, first, defendant's motion in limine number 1 regarding inflammatory language. Defendant moves under 403 to prevent the state from introducing testimony and evidence that is exceptionally inflammatory, arguing it is irrelevant and or unfairly prejudicial. The court finds this motion is premature, and as with any potential prejudicial evidence, the court must consider whether it's relevant to the material at hand under 401 before assessing whether it's even probative under a 403 standard. If the defendant believes that the evidence is cumulative, unnecessary, otherwise prejudicial, he can take the matter up outside the presence of the jury. Defendant's motion limine number 3, use of the term murder. Defendant seeks to prohibit the use of the word murder, murdered, murder weapon, and a similar form of the word murder applied to defendant. Again, the defendant seeks an order requiring the state to abide by the evidentiary rules, particularly those prohibiting against argument outside of closing. Thus, the motion is denied. Use of the term psychopath or sociopath. The defendant moves to exclude any reference to the term psychopaths or sociopaths at trial, arguing that it is unfairly prejudicial under 403 and improper under 702. The state says they don't intend to use the terms at trial, and therefore, thus the state is not going to use those terms. If, however, the state believes the door has been opened to allow the use of such terms, it shall raise the matter outside the presence of the jury. So therefore, that motion is granted. It's almost moot, but the court granted it. State's motion in limine regarding improper death penalty comments. The motion is denied as unnecessary. The state moves under 401 to preclude defense counsel from making what it calls improper comments about the death penalty. The defendant moves in limine to exclude any 404B evidence that has not already been noticed by the court. Defendant notes the state intends to present evidence of defendant's graduate paper regarding how to conduct a crime scene investigation and his Amazon purchase records, both of which defendant contends are subject to 404B. An initial matter, defendant appears to misapprehend the scope of 404B. The rule provides that evidence of a crime, wrong, or other act is not admissible to prove the person's character in order to show that on a particular occasion the person acted in accordance with that character. The defendant takes the position that other acts encompasses any other act of any nature other than the crime at issue. The rule is not so broad. Its purpose is to govern the use of character evidence, and it forbids the use of evidence to show the defendant's criminal propensity. Defendant's Amazon purchases and his graduate paper discussing proper crime scene investigation techniques do not stand alone, bear on his character, or suggest he has a propensity to commit crime, including those charged. Further, the court is unwilling at this point to preclude the state from filing a 404B notice in the future if it determines its evidence is encompassed by the rule. There are still 4 months until trial begins, well within the reasonable in advance of trial time frame required by the rule. The state acknowledges its notice obligations under the rule and intends to comply with the 404B evidence. The timeliness of such future notice will be analyzed, and when such notice is given and objections can be advanced at that time. Therefore, the motion is denied. Improper expert testimony regarding IgG evidence. Both parties moved to exclude evidence of law enforcement's investigative genetic genealogy testing, but only for different reasons. Given the parties' agreement to not present any IgG evidence, those reasons need not be discussed, given the bottom line agreement that the court grants the motion. The state has indicated it will present evidence through Detective Brent Payne that the defendant's name was revealed to law enforcement through a tip. To avoid such issues at trial, the court advises the parties to arrive at a mutual agreeable narrative about how the tip came about. The parties are also directed to jointly craft jury instructions advising the jurors not to concern themselves with the source and nature of the tip. Conditions as aggravator. Defendant moves to prevent the state from using defendant's diagnosis of autism spectrum disorder as the characteristics of his ASD as an aggravating factor for the penalty phase of trial. Despite the state's concession, the court is concerned with the breadth of defendant's motion. He is only seeking to preclude the state from referencing his ASD diagnosis as an aggravator, but any symptoms of his ASD. Given the broad nature of ASD symptoms, the court foresees any issue potentially arising at trial whereby the state makes reference to any action by the defendant that the defendant contends is a symptom of his ASD. This evidence is not currently before the court. Thus, at this point, the court will preclude the state from arguing or presenting evidence of defendant's ASD diagnosis as an aggravator, but it is not in a position to rule on whether any particular evidence must be excluded on the grounds that evidence of symptoms of defendant's ASD. Therefore, the motion is granted in part only. Alternative perpetrator evidence. The state seeks an order prohibiting the defendant from offering alternate perpetrator evidence without first making a showing that such evidence is relevant and admissible under Rule 401 and 403. These rules govern the standard of admissibility. And defendant acknowledges his burden under Meister, but argues the state's motion is premature. According to the defendant, this case is full of alternate perpetrators, and he intends to produce offers of proof as to alternate perpetrators. While the defendant is correct that such offers of proof can be made at trial, this case is not well suited until the time the trial to do so. Particularly, if defendant intends to submit multiple offers of proof, laying foundation for admission of the evidence will likely take a significant amount of time. After all, defendant cannot merely show another person could have committed the crime. Rather, there must be evidence, direct or circumstantial, linking the third person to the actual perpetration of the crime. To avoid undue delay at trial, the defendant must present offers of proof no later than May 14th so that the matter can be addressed at the pre-trial conference. This court will reserve ruling on the motion. So set your calendars, ladies and gentlemen. May 14th, we'll find out if the defense actually has credible alternate suspect evidence. Statistical analysis. The defendant's motion in limine to exclude misleading comments about the meaning of likelihood ratio. The court grants the defendant's motion as it applies to the question asked by prosecutors at the grand jury proceeding, which both sides agree was not proper. However, the court will not dictate how the question is to be asked at trial. If the defendant believes there's similar misrepresentation as to the likelihood ratio at trial, he can object at that time. Inconclusive data. Defendant moves to limit expert testimony about the Idaho State Police Forensic Lab statistic analysis of a swab taken from the fingernail clippings of Madison Mogan. The testing revealed a likelihood ratio in the inconclusive range as to whether the defendant was a potential contributor to the DNA mixture. During her grand jury testimony, the lab analyst Jade Miller testified that inconclusive meant she was unable to say one way or another whether or not defendant is included in the mixture. Defendant argues this is misleading language in that it allows for an inference that the defendant might be included, which he asserts is inaccurate. The state indicates it will not offer the results of Q1.3.1 as inculpatory evidence, which defendant agrees renders his motion moot. However, the state changes its course with regard to the evidence. It must raise the matter outside the presence of the jury. At this time, however, the motion is denied as moot. Click activity. Motion number 9. Defendant moves to exclude any evidence of defendant Amazon's purchase history or click activity on the grounds that it is out of context, incomplete, and unfairly prejudicial. This evidence will be presented by the state through Shane Cox and Michael Douglas, who will testify simply to what documentary evidence state, all of which provided in defendant discovery. The evidence is highly relevant. A K-bar knife sheath was found lying next to the body of one of the deceased victims, all of whom were stabbed to death. Defendant's DNA found on the knife sheath. Records from an Amazon account registered to the defendant's name and email show that a purchase of a K-bar and sheath was made from the account approximately 8 months prior to the homicide. Click activity on the same account shows the customer also viewed pages associated with K-bar style knives at the time, and in the week following the purchase, viewed pages associated with the shipping progress of the knife sheath. The product was shipped to Bryan Kohberger at his family's address in Pennsylvania. After the homicides, activity from the same account showed the user navigated pages related to the deletion of account activity, and a week later, viewed pages associated with a K-bar knife and sheath. This evidence establishes a significant connection between defendant and a K-bar knife and sheath. In addition, there is no basis under 403 to exclude the evidence, particularly given how probative it is. Defendant argues it's misleading and prejudicial because it paints an improper picture of the account activity. To this end, defendant provides the declaration of his expert, David Howell, the founder of a firm specializing, among other things, digital forensic and digital marketplace analysis. And according to Mr. Howell, far more information must be reviewed in order to attribute specific activity to a specific person or otherwise render an opinion about user behavior and forensic certainty, including Amazon advertising logs, recommended algorithms, cross-device history, retargeting behavior, account personalizations, and device IDs. Defendant is free to challenge this evidence through cross-examination and establish through Mr. Howell why more information is needed to reach the conclusion the defendant made the purchase or clicks. However, it is not the basis of exclusion. There is nothing inherently unfairly prejudicial or misleading about the evidence itself, and it will be up to the jury to consider all of the evidence and decide whether defendant was the clicker. Thus, the motion is denied. AT&T timing advance records. Remember, this is the one that the judge got all fired up about. The state moves in limine to prohibit the defense from taking any reference to the absence of AT&T timing records, advance records related to the defendant's cell phone. Court goes on, applying the principles here, defendant will be allowed to voir dire special agent balance outside the presence of the jury to ask whether he received defendant TA records covering the early morning hours of November 13th, 2022 and months prior, when the defendant was believed to have been in the area of 1122 King Road. However, if Agent Balance denies having received the TA records, defendant may not explore the matter further, either in voir dire or before the jury. Given the absolute lack of any factual basis supporting his position that the state is hiding these records, thus the state's motion is granted, except as qualified regarding the brief voir dire outside the presence of the jury. Next, self-authentication records. State moves in limine for the admission of approximately 60 exhibits pursuant to 8036, 8038, and 80324. The state represents that it will obtain and submit certifications for the foregoing exhibits to render them self-authenticating under Rules of Evidence 902.4 and or 11. However, the state acknowledges that 902.11 contains a notice requirement that has not been satisfied. To this end, it will require proper notice given under 902.11. The motion is reserved. Demonstrative evidence. Remember, this is the dollhouse, the 3D scaling. The state seeks permission to use a not-to-scale 3D model, 1122 King Road residence, as a demonstrative exhibit at trial, contingent on the state laying sufficient foundation to establish the basic accuracy of the model. The state contends that the model will aid certain witnesses in describing the testimony. Defendant objects, arguing the state's drawing of the model and other relevant information was only recently disclosed in discovery. Defendant describes it as massive. Defendant claims that the data and model cannot reasonably be evaluated by its expert in time. Defendant disputes the model is relevant, and even if it was, claims it should be excluded under 403 as it might might not be accurate. Trial court has the discretion regarding the admission of evidence. Here, the court finds the demonstrative exhibit is relevant, assuming foundation can be laid because it will supplement the testimony of a witness or assist the jury in obtaining a better understanding of the issue. The homicides occurred in 2 bedrooms within a 3-story home with a complicated layout. The suspect's ability to enter the home, carrying out the stabbing, and exit the home consistent with DM's observations will be a central point of trial, particularly given that the defendant is challenging whether it could be accomplished by one person within the time frame alleged. The model will aid the testimony of the lay witness and experts alike in explaining the location, witnesses, and other evidence. Moreover, though it's not to scale, accuracy is not the standard governing relevance of demonstrative exhibits. Moreover, discussed Mr. Nodal's concerns about the time constraints are based on his impressions that he'll have to analyze the underlying data to ensure the model is proper scale, dimension, and completeness. Again, accuracy is not the standard. Mr. Nodal need only assure himself the model is not deceptive, and there's sufficient time to do so given the trial dates. Motion in limine regarding alibi. The state moves to preclude defendant from offering any evidence in support of an alibi other than the defendant himself. The basis of the state's motion is defendant's failure to comply with the notice requirements governing alibi evidence. The court has the discretion to exclude testimony of any undisclosed witness offered as to the defendant's absence from at the scene of the offense. An alibi is a defense based on a physical impossibility of a defendant's guilt by placing the defendant in a location other than the scene of the crime at the relevant time. Hence, in setting forth the notice requirements for an alibi defense, statute requires the defendant proffer evidence establishing where the defendant was at the time of the alleged offense. Evidence only counts as an alibi evidence if it proves the defendant could not have been present at the scene of the offense at the time it was committed. If any alibi fails to account for a defendant's whereabouts for at least some period of time which the crime is reasonably committed, it is not an alibi. At this point, defendant has only provided notice that he was out driving in the early morning hours of November 13th throughout the area of South Pullman, Washington, and west of Moscow, Idaho. He intends to present testimony by his expert, Cy Ray, to partially corroborate his alibi using the cell phone tower location data from defendant's cell phone. However, the alleged offense occurred between 4:07 and 4:20 a.m. At most, Mr. Ray can opine as to where defendant's cell phone was up to 2:54 a.m. when it was apparently turned off, and approximately 4:48 when it began reporting to a network. Defendant has provided no evidence as to his location at the time of the crime. In other words, he has provided no alibi evidence as contemplated by the rules. That said, the court will not categorically preclude defendant at this point from offering alibi evidence at trial. There are still 4 months until the trial begins. If the defendant does unearth alibi evidence, it is his obligation to immediately make the state and the court aware of it. At that point, the court can apply the Juarez standard. Excluding it at this time is premature, and therefore the motion is denied, subject to being re-raised. However, at this point, the defendant has not provided an alibi, partial or otherwise. 404B evidence, traffic stop. The state moves under 404 for the admission of defendant's August 21st, 2022 traffic stop in Moscow, Idaho, during which he was stopped for speeding and issued a citation for failing to wear a seatbelt. Specifically, the state seeks to admit the officer's observation and his body cam footage of the traffic stop, as well as the citation, arguing is relevant to proving defendant's identity, vehicle ownership, and control, address, and phone number. The defendant objects, pointing to the Supreme Court case law stating that evidence of prior misconduct is relevant on the issue of identity when the evidence demonstrates sufficiently similar as well as distinctive characteristics or patterns between the prior misconduct. Evidence of other crimes, wrongs, or acts may not be admitted pursuant to 404B. Such evidence may, however, be admissible for other purposes, including to prove identity. 404B. 2. To determine the admissibility of evidence under 404B, the court must find the evidence is sufficiently established as fact and irrelevant as a matter of law in material disputes, and it must conduct a 403 analysis. The court finds the evidence is relevant to establish defendant's identity and link him to the charged crime. Indeed, the citation and the body cam footage, up to the point the defendant provides his phone number, serve to identify defendant by name, physical appearance, phone number, and address. The evidence also established defendant as the registered owner and driver of the vehicle, and the make and model of which was thought to be used by the killer. Further, the evidence places defendant in Moscow at the night on one of the dates of interest alleged by the state to be relevant to planning the charged crime. All of these factors played a role in the investigation of the crime. While the defendant cites two case law discussing identity under 404B as required strong similarities between the bad act and the charged crime, this is the context of establishing identity through a similar quality or modus operandi. The state, however, is not seeking to introduce the prior traffic stop to establish modus operandi. Therefore, the defendant's case law and argument is not well placed. Upon weighing the 403 factors, the only portion of the video footage the court finds troubling is when the defendant inquires why the officer needs his phone number. This inquiry could be perceived by jurors to be insolent. Given its lack of relevance and potential for prejudice, the inquiry shall be redacted. Other than this redaction, there is no basis for further exclusion. Defendant's claims of unfair prejudice and jury confusion lack merit. Defendant also contends it's unfairly prejudicial because the body cam footage provides a clear shot of defendant's vehicle, which may lead the jury to believe it is the suspect vehicle captured on the surveillance video at or near the crime scene on November 13th. However, this is precisely what makes the evidence probative. It links defendants to the crime scene. While this may be damaging to his defense, it is not unfairly prejudicial when balanced against strong relevance. This motion is granted with the notice redaction. That's the big one, right? All those things that the prosecution wanted to bring in, the defense wanted to keep out, all of it just about coming in. And the last big one, neurological and psychiatric evidence. The state seeks to prohibit defendant from offering any testimony during the penalty phase in connection with his neuropsychological and psychiatric evaluations performed by his disclosed experts, Dr. Rachel Orr and Dr. Eileen Ryan. The state argues the proposed testimony falls outside the mental condition evidence allowed under Idaho Code 18207. The defendant responds that it is not relying on the proposed testimony as a mental element defense under 18207, noting his relevant diagnoses are physical conditions, not mental conditions. Rather, he intends to present the evidence to aid the jury in understanding both the physical implications of his diagnosis and contextualize his alleged unconventional courtroom demeanor. The court finds that if the defendant does not testify, evidence of his diagnosis to explain his courtroom demeanor is not relevant and or inadmissible under 403. Ruling is reserved as to certain behaviors that may become relevant in rebuttal, except for expert testimony that he was physically unable to commit the crimes for which there is no disclosed opinion. I'm going to jump to near the end. It says, if the defendant testifies, evidence to explain his demeanor may become relevant. At this point, defendant's demeanor, which goes to his credibility, is relevant evidence to a jury, and they consider which the state concedes. However, prior to presenting testimony on the matter, defendant must raise the matter with the court outside the presence of the jury. The court reserves ruling on admissibility of OCD evidence. Defendant argues that evidence of his physical manifestations of OCD may be relevant in the rebuttal. Those manifestations, according to Dr. Orr, including compulsive hand washing, wearing gloves to avoid germs, and generally avoiding anything contaminating. Defendant further adds in argument only that his OCD causes sleep difficulties that have led to a habit of driving at night and running to decompress. He argues that if the state elicits testimony at trial related to these facts in order to support elements of the crime, the evidence of this manifestation will be proper rebuttal. The state responds that it does not intend to introduce any evidence during the guilt phase as to defendant's odd behaviors, social miscues, or other unusual behavior. However, it requests that the court reserve ruling at that time. The court finds this is an appropriate approach. Again, prior to introducing such evidence and otherwise mentioning before the jury, defendant shall raise the matter outside the presence of the jury. Evidence of DCD is not admissible to rebut ability to commit the crime. OCD. As with OCD, defendant argues he intends to introduce evidence of deficits of his fine motor dexterity and visual motor function caused by DCD to rebut the state's evidence that it was possible for him to have acted with the speed and coordinated requirements to commit the crimes. The state responds that the defendant is improperly stretching the bounds of his expert opinion to reach an inference that cannot reasonably be drawn, which was not disclosed and which otherwise has no support. It argues that the evidence is not relevant to guilt and or is barred. The state challenge is well placed. Whether the defendant was physically capable of the speed and dexterity to commit the crime on account of his DCD is within the realm of expert opinion. Dr. Lewine observed DCD is characterized by impairments in the development of motor coordination, including dexterity, limb speed, and gross and fine motor skills. It is associated with structural and functional disruptions of motor control and coordinated networks with minimal modulation by psychological factors. However, it is not a diagnosis from which defendant currently suffers. In her report, Dr. Orr noted DCD was a diagnosis for which the defendant met criteria in the past. Further, there is nothing in her disclosure a report suggesting defendant was physically unable to commit the crime due to impairments associated with the DCD. Her entire discussion on the defendant's DCD is as follows. Defendant's education history, parents report, and evaluation result all provided evidence that defendant experienced significant deficits in motor functions in the course of developments, which in turn contributed to problems meeting physical, motor, and coordinated milestones of childhood. While motor problems have not impacted his functioning significantly in years, defendant continues to present with more impairment in fine motor dexterity and vulnerability in visual motor functions, evidence in his cognitive profile. The only observation Dr. Orr made with regard to the defendant's fine motor dexterity was the defendant moved his whole arm and repositioned his upper body slightly to manipulate items effectively. In her cognitive profile, she stated the defendant's visual motor skills were relatively weak in this context of his overall profile, particularly when precision of dexterity. The foregoing represents the extent of the expert commentary defendant's DCD. Nothing therein remotely approaches an opinion about defendant's ability to commit crimes. At most, Dr. Orr could testify about her observations about his weak fine motor dexterity and visual motor skills, but without any opinion trying this evidence to his ability to commit the crime. His relevance is lacking, and it invites unsupported speculation by the jury about defendant's ability to commit the crime. Additionally, there is again concern the expert testimony will consume an inordinate amount of time on an issue of which there is no foundation in a trial that will already be lengthy. Weighing this concern, given the lack of any probative value, further warrants the exclusion under 403. Therefore, the neuropsychological and psychiatric evidence is granted in part and reserved in part. All right, there you go, ladies and gentlemen. All of those orders. I know that was a lot. You got a few little new tidbits out of the information. We know now that the knife went to the home in Pennsylvania. Somehow it got there. The fact that he was looking at those replacements, we knew that a little bit already, but always something a little new when you get these orders, because remember, the court is looking at stuff that we don't already get. All right, let's do the docket very quickly. First, Luigi Mangione was indicted on federal murder charges for the killing of the United Healthcare CEO, Bryan Thompson. Everybody expected that, and it is eligible for the death penalty. The Karen Reed trial. Obviously, we've brought you the information. The trial begins next week. Another motion eliminated that the defense not mention in opening statements any of the victim's injuries were caused by any person or animal that was inside the home at the 34 Fairview Road. Based on the defense requested to show abrasions to the victim's arm in opening statements, the Commonwealth notes that the court has ruled the defense is precluded from mentioning any reference to third-party culprits claiming to establish a viable basis supported by admissible evidence. That's reasonable. The defense should not be able to do that. Next, a federal judge has declined to delay the trial of Sean P. Diddy Do It Combs, meaning the music mogul's trial is still set to commence in May. Then we have this day in legal history. On April 18th, 1918, the Sedition Act is debated in Congress, later passed to criminalize anti-war speech impacting First Amendment law during World War I. On this date in 1934, the FBI kills gangster Homer Van Meter and Marie Comfort in a Minnesota shootout, escalating federal efforts against Depression-era crime. On this date in 1963, Gideon v. Wainwright decision impacts spreads with states expanding public defender system, reinforcing the right to counsel. That's right, Gideon v. Wainwright. Guy says, hey, I need a lawyer. Petition to the United States Supreme Court from his cell in Florida. Supreme Court took it up, and he won, pro se. Well, he got a lawyer when he got Supreme Court, but he did it all himself. Next, on this day in 1980, the Supreme Court in Oregon v. Smith, limiting religious freedoms claims influencing legal boundaries of First Amendment rights. On this day in 2007, the Supreme Court upholds the Partial Birth Abortion Ban Act in Gonzalez v. Carnhart, a key reproductive rights ruling. And our dumb criminal of the day. The OnlyFans model, who was recently arrested for spraying her urine on more than $1,500 worth of merchandise at a New Hampshire grocery store, has been hit with 5 more criminal counts for an alleged pee spree at a hotel. In a series of criminal mischief complaints filed beginning on April 14th, Kelly Tedford has been accused of damaging an assortment of items in a Marriott in Keene, Massachusetts on January 14th. Investigators allege that Tedford, who used the handle Kinky Kelly, an OnlyFans, urinated into a hotel room's air conditioning unit and relieved herself on a comforter, blanket, curtain, and a Bible. She's also charged with defecating on the floor and placing the waste inside the toilet tank, a frat boy favorite known as the Upper Decker. At the same time, the new misdemeanor counts were being filed. Tedford was named in an indictment charging her with felony criminal mischief for allegedly contaminating items of another food store there in Keene. Tedford's alleged target of the grocery store in February, resulting in the business suffering a loss of $1,500 in destroyed merchandise and having to clean up the mess as well. Investigators contend that Tedford recorded her antics for, the $15 a month OnlyFans page fee, which is no longer online. Tedford's page described her as a submissive pixie, fetish, kink, friendly extremist as well. Her account also offered subscribers custom content and paid sexting sessions. Her previous OnlyFans page was deleted, Petite Princess, because it got banned. While the Kinky Kelly page appears to have been deleted, explicit videos of Tedford's remain online, including one clip showing her urinating on new garments in a clothing store changing room. I don't know, Miss Tedford, that's just gross. But you're a dumb criminal of the day. I know it was a long show, ladies and gentlemen. Hope you enjoyed it. We'll see you next time. Remember, the Constitution matters.